So this scenario is hard, and it's actually something that I've had a lot of consultations on in recent months. Because even though in my practice I've seen USCIS be much more open to O1s than they have been in the past, and much more willing to consider granting an O1 just based on meeting the criteria and the plain language of the criteria. A lot of immigration attorneys are still focused a lot on the prestige factors, where they're really looking for someone who's risen to the top of their field. And they're almost doing more of an EB1A, a higher standard analysis, when they're looking at the prospective O1 cases. And I don't think they're really fully taking into account the trends, the recent policy guidance. It's not really their fault. A lot of times, the attorneys who are assessing these cases have some prior trauma from the past Trump administration where it was so difficult to get an O1. And then they just haven't filed very many O1s recently because they were operating on the fact that this is a high standard. There's also this idea that they're protecting the company. And so they don't really want the company to have a lot of denials on its record. I'm not sure how much USCIS actually cares about a company's approval record. I don't think it's something they really track or notice. I guess if a company got almost every single petition denied, it might matter a little bit more. But this is the attorney's mindset oftentimes going into the assessment or the evaluation. And it does color how much they're willing to work with the individual. A key to convincing them is outlining the criteria and then affirming that you have talked with other legal counsel, and that they have said it's a more than 50% chance of being approved, or at least it's worth a chance for filing. Another thing you can do, and this is something that's unique to the O1, you can't do this with H-1Bs. But another thing you can do is tell the company that you are willing to bear the cost of the petition. If you are willing to pay, the company doesn't really have any risk in sponsoring you for O1. I guess their risk would be getting a denial and thinking that that denial might impact other cases, which it probably doesn't. But that's probably the only risk factor they're looking at, as long as you are willing to bear the cost of the case. So I do recommend that everyone kind of offer to pay. That doesn't mean the employer is going to accept it. The employer might want to pay, or the employer might think if they are going to sponsor that they should pay. And, to a degree, that's true. They really should. But offering to pay oftentimes can remove the barriers and help out with the case quite a bit. I've still worked with a lot of clients where the company says, no, they're not going to do it. There's no way they're going to do it. They're not going to consider it. It frustrates me so much because for someone to say they're not even going to try, even if it's a minimally viable case and not the strongest case ever, it removes options, and it's just really, really discouraging. But there might be a couple of things that you can do to get around this. So the first way is you can do this kind of test O1 if you go through pathway A, like I described before, where you set up your own consulting company so that you can have your own side gig. And if you get the O1 approved through that company, you would then be able to provide services to your own clients, and you can even show your existing employer, hey, I did get the O1 approved. Are you sure that I can't just switch over to O1 with you as well? The tricky part in this is you can't do anything that cancels out your existing status if you want to keep your full-time job. So it would be very, very, very important, if you do go this route, to file the O1 as a consular petition, essentially as one that does not take effect right away. It does not automatically change your status. It's just a pre-approval, which you can then take to the consulate, get an O1 visa stamp, and then enter the US and start working on the O1. And I can't emphasize enough how important that is if you're using this kind of petition as a test O1 case. This pathway is not necessarily going to work for everybody as well. And I do want to get into a little bit of detail there, because I think the US government is much more willing to approve an O1 if it's tied to an existing legitimate company that has some name recognition. For example, there's a criterion that you can use to qualify for O1 called performance of a critical or essential role at a company that has a distinguished reputation. It's very easy for someone who's working at a big name brand company to meet this criterion. However, if you're applying in your own startup context and your startup doesn't have any clients yet, and really doesn't have any reputation at all, it's harder to claim that criterion and have USCIS like rely on it and approve it. You can always say, I am also working at Microsoft or this other big company, and try to claim the criterion and rely on it based on that. But there is going to be just a little bit more of a hurdle in getting that approved. At least that's my perspective on it. I will say it is a little frustrating not knowing for sure how the USCIS officer will treat these factors, weigh these factors, and whether or not they'll approve the O-1. It is very discretionary, and that discretionary aspect leads into a lot of these lawyers saying, no, we're not even going to try it. But these things are worth a try. And I think there's a lot of room to think creatively, even if there's no easy answer. But this is a trending topic. A lot of people are running out of options and really want the O-1. And I really wish the rest of the field was embracing the spirit of being a little more creative and allowing it. And it just doesn't seem like they are.